Good evening. To those students who are already online, please give me a confirmation that you can hear me, and also make sure that you inform your friends that we are live now so that we can continue where we were left, where we had left in the morning session, and we will discuss further more provisions of CA Foundation, Business Law, Contract Act was going. So we have Omkar here. Very nice. I can see the responses. Omkar, graduate boy, Lucifer. So all these funny names are there. So Mahidhara is there. Yes, very nice. Nice to see you all. So we'll start back. We'll discuss our provisions, and we will continue our discussion on Contract Act. We had discussed in the morning session about Unit 1 of Contract Act. Continuing further, we also discussed about Unit 2 consideration. We had discussed about important provisions of consideration. What next? What comes next is a doctrine called as Doctrine of Privity of Contract. Now, in Doctrine of Privity of Contract, what are the things you have to keep in mind? What are the possible areas where we can expect the questions? And what exactly are we going to focus in this particular area? This is what we need to see. So going into this topic, Doctrine of Privity. Privity means party to the contract. So what does it say? It simply says stranger to the contract. Stranger to the contract cannot enforce the contract. Stranger to the contract cannot enforce the contract. This is what Doctrine of Privity of Contract says. Yes. There can be a stranger to the consideration. There cannot be a stranger to the contract. That means a party who is not there in the contract. The party who is not entering into the contract cannot enforce it, cannot go to court. This is what we are discussing here, correct? This is what is the provision that needs to be discussed. Moving on further, there are certain circumstances where even if the party to the contract is a stranger, he can still enforce the contract. Correct? Can we please have some situations or circumstances where even if in these particular cases where we have discussed strangers cannot enforce the contract, what are the exceptions to this particular rule? Under what circumstances, even if there is a stranger, he can still enforce the contract? Can you name certain transactions or can you name certain contracts where even if there is no consideration, there can be a valid, sorry, I mean not a no consideration part, that is already discussed, where even if the party is a stranger to the contract, he can still enforce the contract? What are the circumstances? So first one, they say in case of contract of trust. In case of contract of trust, beneficiary of the trust. Beneficiary of the trust. See, this can be a straightforward theory question. This entire thing can be a theory question. Or they can expect you to answer it based on a particular case law. Or case-based analysis can happen. There can be a case-based analysis. So, in case of trust, second one is in case of family settlement. Very nice. Family settlement. Family settlement. Normally, they can give a scenario whereby two brothers enter into an agreement to share the property of their father and to look after the marriage expenses of their sister. In this case, tomorrow, if they don't pay the marriage expense of their sister, she can sue upon the enforcement of contract. This is very much possible. So, certain family settlements. In case of family settlements. Then, in case of marriage contracts, certain marriage agreements, not all marriage agreements, certain marriage agreements. Certain marriage agreements. where one party promises father-in-law, stating that he will not ill-treat his wife, he will not ill-treat his wife. And later on, when the person ill-treats the wife or the daughter of that person, can enforce the contract. This is what it says, certain marriage agreement part. Certain marriage agreement. Yes. Then, in case of acknowledgement, very nice. In case of acknowledgement, acknowledgement means someone acknowledging that he has money that belongs to someone else, he has goods of someone else, and later on when he denies to give that particular goods, actual owner whosoever is there, he can still enforce the contract. So that is in case of acknowledgement. Then in case of assignment of the contract, very nice, the assignee can enforce the contract where the benefit of the contract gets assigned. Then in case of assignment, then what happens? Then in which case? Then covenant running with the land, very important, covenant running with the land. Covenant running with the land. Covenant running with the land is an important part. Again, here that case, Mohanlal case, whatever is there, Sohanlal case, whatever is there, in that covenant running with the land will also come, because there is a promise that son will have the right. Son will have the right to do any activities in any one of the acres. That is why that question may come here also. So based on this also, you can expect the same question. So Mohanlal question becomes important in this case also. And last one is contracts entered through agents. Agency, in case of contract of agency, even though the contract is entered with third party by the agent, principal can still enforce the contract. Principal can enforce the contract. So these are the provisions with respect to doctrine of privity of contract. So again, this is important because you can expect a theory question here, or you can also expect a practical question based on any of these scenarios. So this becomes an important area. So all three areas in consideration are important. All three areas in consideration are important. Now moving on further, that comes to the end of unit number 3. Unit number 3, we saw one section, that is section 25, exceptions to section 25, and all other things which relates to doctrine of privity of contract. These are the topics that we have discussed in unit number 2. Moving on further, we have to go for unit number 3 now. In unit number 3, there are certain important areas purely from the examination perspective. Of course, by learning perspective, we have so many things to cover. But purely from examination perspective, if I have to discuss, there are certain areas which are very, very important, which cannot be ignored at all. First one being section 11. Section 11 tells us about capacity of the parties. Capacity of the parties. Who are the parties capable of entering into an agreement? Who are the parties capable of entering into an agreement? First one being person who has attained the age of majority. Age of majority. Second one, person of sound mind. Third one, not expressly disqualified. Person who is not expressly disqualified. These are the three categories of persons who are capable of entering into an agreement. Very nice. It is very really nice to see people responding in the chat box. You can respond because this is revision session. This is your session. What I am doing is I am just giving the beginning of the provisions. I'm just starting the provisions. You can definitely join me in answering the questions. Very nice. So capacity of the parties. Very important thing you have to understand is, if person does not satisfy any of condition, agreement with such person shall be dash if any person does not comply with the requirements, whatever is said here. Yes, agreement with such person shall be dash. Fill in the blanks. Of course, we are not writing the multiple choice paper. We are writing 100 marks descriptive. Sorry, we are writing 60 mark descriptive paper. Still, it is important to identify these type of agreements. What and all types of agreements are these? It is better if you can identify them, because it becomes simpler while answering the provisions. It shall be void ab initio. Very nice. It shall be void ab initio. Very nice. Sir, void ab initio. One more important observations we have to make. Void ab initio, void agreement, void contract. Are they same or they are different? Sir, void agreement and void ab initio. Void ab initio is a status. Void ab initio is a status. Void agreement is a type. You should understand this very clearly. Void ab initio means something that is void right from the beginning. See, if you take any void agreement, all void agreements are void ab initio. Agreement with minor, agreement with unsound person, agreement with disqualified person, agreement with an alien enemy. All these things are nothing but void ab initio. Right from the beginning they are void. Right from the beginning they are void. Having said that, void agreement is void ab initio. But sometimes what happens, when the contract is entered, the contract will be 100% valid. Later on, it becomes impossible to perform. Section 56 will come. Impossibility of performance. Section 56. That is when, what happens is, that is when you just switch on to void contract. That is what is called as void contract. Void contract means something that is valid when you entered it, but later on, subsequently, it becomes void. Impossible to perform. That is why void. So void contract it is. Contract which became void. That is why void contract. Void agreement is void ab initio. So these things differentiation you should be very, very clear with. Agreement with minor is void ab initio because he is expressly disqualified under law. Law says he cannot make a contract. When minor enters into a contract, it is considered as void ab initio. Yes. Now comes an important area. What are the possible questions when it comes to agreement with minor? Possible questions. Possible questions. First one is status of agreement with minor. Definitely you have to remember Mohiri Bibi versus Dharmodas Ghosh. Mohiri Bibi versus Dharmodas Ghosh. Important case law, which tells us agreement with minor is void ab initio. Any agreement done with the minor is void ab initio. Second important thing is no ratification on attaining age of majority. Ratifying means approving a past act. Ratification not possible. When you do an act when you are minor, you borrow money when you are a minor. After attaining the age of majority, you cannot come and say that I'll pay. I'll promise to pay. It will not be a valid contract at all. Something which is void ab initio right from the beginning cannot be validated later. So that is why no ratification. Ratification means approval of a past act. This can be a possible practical question area. Ratification. Can the minors agreement be ratified? Answer is no, sir. Minors agreement cannot be ratified. It cannot be ratified at all. Okay. Third important case. There can be a theory question. There can be a theory question stating minor can be a beneficiary or can take benefit after the contract. Elaborate. Explain. Give reasons. See, when this type of question is asked, what is the expectation of the institute? Institute wants you to elaborate it. So how to elaborate, sir? Wordings of ICI material. If you use the wordings of ICI material, it will be better. If you stick to the wordings of ICI material, it will be better. So You focus on this particular area to recall this particular area. I'm not saying for every area you have to by heart the institute material, but there are certain areas where you can expect some questions. One among them is this one, where there can be a straightforward question. So what is the expectation is you are required to write this example and other things. So that is why I'm writing that part also. Minor can be beneficiary. Minor can be beneficiary. Another important area in minor. Another important area to be observed. Next thing that must be observed here is minor can always plead minority. Once a minor, always a minor. Array, that doesn't mean that. Once a minor, always a minor means even if he is misrepresenting his age and enters into an agreement while he is minor, he does a fraudulent representation stating that, sir, I am a major, and then enters into an agreement. Tomorrow, when the question of recovery of dues from minor comes into picture, minor can still plead the minority. Minor can still plead the minority. So, minor can always plead minority. Minor can always plead minority. Possible question area. Now here, what can be the possible question area, sir? They'll say minor goes to a laptop shop, misrepresents his age, and makes the shopkeeper enter into an agreement for selling laptops. Later on, he claims minor. Can the shopkeeper recover any amount from minor? Is the question. If this kind of question is asked, you have to resort to this particular point. So how to write the answer, sir? Answer is very simple. You write, as per section 11, a person who has not attained the age of majority is disqualified from entering into a valid agreement. He cannot make a valid agreement. Such an agreement is void ab initio. Moving on further, minor can always plead minority. That means even when the minor misrepresents his age and enters into a contract, rule of estoppel doesn't work against minor. So minor can always enjoy or claim that he is minor. Minor can always plead minority. But in this case, there's one step ahead. You have to think and you have to write the answer. Court has a power. Nothing can be recovered from minor, but where any benefit is derived from such contract, if it is not spent by minor, that means you can match them or you can trace them. This is the benefit derived and this is available. If you can trace them, he may be asked to repay it. He may be asked to repay it. Remember this is as per specific relief act. So this can also be a part of your answer here. This can be included in your answer. Important observation to be made. Yes. But no personal liability. So these are the points to be covered in this particular area. Important heading. Next important thing you have to remember is section 68. What is section 68, sir? Section 68 is a part of quasi-contract, correct? Section 68 is a part of quasi-contract. 68, 69, 70, 71 and 72. These are the provisions to be understood under quasi-contract. One among them is section 68. What does section 68 say? When minor or any person incapable of entering into contract or for their dependents, they are supplied with any necessaries. Important wordings, supply of necessaries. To person incapable of contracting. And if there is any sufficient property with such person has properties, then the said amount can be recovered out of the properties, the value of the necessaries supplied. I repeat, the value of the necessaries supplied. Important wordings to be kept in mind, sir. Value of the necessaries. Why I say value? Because sometimes they twist a question and they say, minor and another person enter into an agreement. Let us say, minor and person A or Minor and Sahana, for example, there is Sahana here, we'll take her example. Minor and Sahana enter into an agreement whereby Sahana agrees to supply medicines to a minor for a consideration of 5,000 rupees. Sahana supplies the medicines. Let us say the cost of the medicine supplied or the value of the medicine supplied is 3,000 rupees. Normally, the question will be, how much can be recovered from minor? Is it 5,000 or 3,000? Can you recover 5,000 or you can recover 3,000? Can you give me an amount here? 5,000 or 3,000? Yes. Yes, sir. Hello, Ji. Yes, Anil. Hello. Anil is saying hello, sir. Hi, sir. Omkar says 3,000. Mahidra 3,000. Sahana 3,000. Vaishnavi 3,000. Very nice, very nice. 3,000. Vivek says 3,000. Lavanya says 3,000. Very nice. 3,000 is the amount, sir. 3,000. Not the value of the necessaries. Only the value of the necessaries, not the contracted amount. Because contract is void ab initio, sir. Contract is void ab initio. But what exactly is the thing? Is you are recovering the value of the necessaries under the principles of quasi-contract. Quasi-contract provision, sir. That means even if there is no essential elements of valid contract, still law imposes that there is a contractual obligation. That is quasi-contract. So based on that principle, we are answering this question. That is why section 68. You should remember that only the value of the necessaries will be recovered, not the necessary itself or not the contracted value. Remember it. Very important. Yes. So that can be possible question here under section 68. Then what is more important here? What more things are important? See, partnership part I'm not going to touch here because we already have a discussion in partnership pact. So there we can cover that. So partnership part is okay. Then what comes? After that, what is important here is joint contract by minor and adult is an important point you have to observe. Joint contract by minor and adult. Only adult can be held liable and not the minor. Minor cannot be held liable. This is important. So Saindas versus Ramchand case is there. Saindas versus Ramchand is nothing but it is an explanation for that particular part, where minor and major, two parties are there for a contract and they enter into a contract with the third party. Only the major can be held liable, minor cannot be held liable. That is the provision with respect to joint contract by minor and adult. Yes. So these are the possible areas when it comes to minor. Of course, there are other points, but importance wise, if I have to say, examination oriented points I am saying, these are the important points which you have to keep in mind. Yes. Of course, selective reading is not a valid thing. Given the institute pattern of questioning questions and answers and all, selective approach is not a good thing. I'm not selecting any provisions for you here. What I'm doing is based on past exam question papers and based on my analysis, whatever I feel as very important that student has to focus on, only those areas I am covering here. That doesn't mean you have to skip the other things. If you are well versed in other things, please keep revising, please keep recalling them. But for those students who feel we need in the last moment of the examination, we need something that is very important for us, something that we can repeatedly recall, something that we can give weightage for. So if that is if there is your intention, definitely this is the things I'm saying. These are the areas. These are the 6 different areas where you have to focus on. Yes. So this is what is with respect to agreement with minor part. I hope we are very clear here. Yes. Please give me a confirmation if you are clear here so that I can proceed for the next topic. So agreement with minor. We were discussing section 11 and under section 11, these are the topics we have discussed. Shall we proceed, sir? Please give me a confirmation that we can proceed ahead and we can go for the other topics. Shall we? Yes. Let us go ahead. Let us go ahead and discuss section 14. Let us go ahead and discuss section 14 here. Section 14. What is section 14, sir? Can you recall what is section 14? Section 14. Section 14. Section 14. Very nice. Section 14 speaks about free consent. Free consent. So what does it say? Consent is said to be free unless it is caused by. Consent is said to be free unless it is caused by. There are a few factors, very important things to be kept in mind. There should not be any coercion. Sorry, coercion spelling observe. Don't write wrong spellings. coercion. Coercion. Coercion, undue influence. Fraud. Misrepresentation. Mistake. These are the 5 elements. If they are present in any agreement, I'll say there is no question of free consent. If none of these are there and the consent is obtained, I'll consider it as free consent. Consent means consensus ad idem. People agreeing upon same thing in same sense is called as consent. That is what is defined. So let us go for the basic elements of these things. I'll just give you the briefings. I'm not going for the exact definitions and other things. I'm just giving the briefings here. Coercion. Coercion means what? Either committing or threatening to commit an act forbidden by Indian Penal Code, or unlawfully detaining or threatening to detain any property. Why? With the intention of obtaining the consent of the other party or making the other person enter into an agreement. It is called as coercion. Keywords you have to remember. Keywords, very important. What are the keywords you have to remember? Keywords is that either committing or threatening to commit act forbidden by IPC, or unlawfully detaining or threatening to detain any property. Very, very important. Very, very important. Wordings are important here. You have to focus on. So this is what is coercion. Then comes undue influence. In case of undue influence, there are two conditions to be satisfied. Again, two conditions to be satisfied is called as undue influence. Only then it is called as undue influence. Number one, there should be a relationship subsisting between two parties in such a way that one party is in a position to dominate the will of the other party. Second thing is, such party in superior position takes an unfair advantage over the other. That is important. Having a relationship is not undue influence, sir. Just because a superior party and an inferior party enter into an agreement, that will not make undue influence. For undue influence, what is important is misusing. Unfair advantage must be taken. Unfair advantage. Only then I'll call it as undue influence. Very important. Only then it is called as undue influence. So again, important area to be kept in mind. Then fraud. 5 different activities normally is called as fraud. Statement as to fact which is not true by person who does not believe it to be true. Second one, active concealment of fact. Third one, promise made without intention of performing. Fourth one, act fitted to deceive. Fifth one, any act which is considered as fraudulent under provisions of law. Sometimes people will ask, sir, how important are these wordings? See, when it comes to law paper, very much importance should be given to the language that you use in your paper. Very important. Lot of importance should be given to the language that you use. Especially in the provision part of the paper. Whenever you write a case-based question, your importance should always be for the provision part. Provision part carries highest weightage of marks. And always remember, even in law, we can simply say that there is stepwise marking. Though here the stepwise marking is not equivalent to what happens in your accounts paper. Here stepwise marking normally goes for the division of the answer, provision, analysis, conclusion. How clearly you do this. Based on this division, the markings will happen. So when you present your answer, you should pay attention that the provision part is always put up in the most clear way possible. That is why you should put all the effort to remember certain important provisions and important wordings in that particular provisions. These sections, whatever is there, coercion, undue influence, they have some technical words to remember. And it is very essential that you remember all those technical words. So that if a question comes from these areas, you will be in a position to present it in a better manner. Because that itself gives a lot of weightage for your answer. So in law, proper preparation is one step. Proper presentation is second step. Both of them are very essential when it comes to paper presentation. Because few people, normally what they do is, they are pretty well with remembering the provisions. They remember the provisions, they practice a lot. But the problem is they fail in presenting the papers. That is why the more and more you practice, and while you practice also, you should be giving importance to these things, dividing the answer into proper categories, provision, analysis, conclusion, this particular part, division of these parts are all very important, and giving highest weightage for the provision part. Because you see, analysis part takes no lot effort, because whatever is given in the question, you are analyzing based on the facts given in the question. So that should not be much difficult job. Conclusion is nothing but an answer to the question asked in the whatever the question, point of question is there in the question, in your case question. For that, you are answering it through this particular part. So whatever from your end, there should be a contribution. Whatever, if there is contribution from your end, and that is going to be the provision part. So provision part should be very much clear and very much thoroughly written. And always, when you write the answer paper, don't tell a twisted tale. Don't make it so complicated so that the evaluator feels it so complex to understand. Put it very straightly. If you are answering it based on a particular provision, put it very straightly on the face that this is the provision I am using and this is the answer. So be very sure with the provision that you are using for answering the question. Please make sure that you are using these techniques in your answering. Okay, continuing further, we have misrepresentation. Misrepresentation, normally in a layman's language, if I have to say, misrepresentation is nothing but activities of fraud done without any intention of defrauding the other person. Innocently you are doing. Of course, we have a technical definition which says statement as to fact which is false by person who does not believe it to be true, or breach of duty, bringing an unfair advantage, or causing the other person mistake, howsoever innocently, I'll consider it as misrepresentation. These are one clusters of sections. Of course, the predominant section here is section 14. All these are branches of section 14. They form a part of section 14. So very important things to observe. Out of these sections, there are two more important sections which you have to compulsorily remember. Any question from this area should be answered using that particular provision clearly. Section 19 and section 19A. Mark my words. If you are writing this section 19 and section 19A for any question based on these particular provisions, definitely you're going to score better marks. Effect of fraud, effect of coercion, effect of fraud, effect of misrepresentation, that is section 19. Effect of undue influence, section 19A. Now, section 19, what does it say? When the consent is obtained by coercion, fraud, or misrepresentation, the party whose consent was so obtained has an option to avoid the contract, or the contract is voidable at the option of the party whose consent was so obtained. Now, when it comes to fraud scenarios where contract is made to be entered under fraud, see, remember these wordings, whatever I am saying now, these are very, very essential, very, very important. And if you stay onto these basics, definitely, if you are writing an answer, it will add value to your answer. Please make sure that you remember these provisions. So here, what is to be remembered, sir? Section 19, effect of coercion, already discussed, voidable. Fraud also voidable, misrepresentation also voidable. In case of fraud, there is something extra that you have to remember. Wherever there is a fraud and the party is made to enter into an agreement through fraud, the party whose consent was so obtained can maintain a suit for damages. He can recover the damages, loss what he is suffering. The damages can be recovered. Remember this particular provision clearly. Or he can also claim for specific performance. Whatever has been promised, that must be performed. He can ask for specific performance. So this should also be remembered. In case of misrepresentation, there is no question of damages. Only in case of fraud, damages will come. Misrepresentation case, there is no provision for damages. Remember this point. So if the question is based on misrepresentation, don't try the factor of damages. Now, one more thing you have to remember here. There can be a possible question on this also. That speedometer case normally they ask. A person sells his car or scooter, claiming it to be in fit condition. Both speedometer and accelerometer are working perfectly well. And the person selling claims some mileage, saying that this is the mileage of the car. Later on, the person who purchases the goods discovers that the vehicle is not giving so much of mileage. Can he avoid the contract based on these grounds? Whether on these grounds, can the contract be avoided? Now see, the provisions clearly state that where the person has option to conduct some inquiry or where he can discover the truth, all the means of discovering the truth are available. Still, he ignores to discover them. Later on, when he finds any fault, it does not amount to fraud. It will not be considered as fraud. You're not going to consider it as fraud. So that is why that part also becomes very, very important while answering the question. So it is not fraud then. In such a case, I will not consider it as fraud. So this part should also be kept in mind while answering the question. Further, sometimes what happens? Consent obtained may not be based on fraud. That means in that particular thing, fraud might be there, but the consent obtained by the other person may not be based on that particular fraud activity. So then also, mere fraud, based on mere fraud, the contract cannot be avoided. So this is also to be kept in mind. Both are important. Both provisions are important. You have to keep in mind mandatorily. So effect of fraud content, whatever is there in your material, ICA material is important. Very, very important. Please pay attention to them. Yes. So that is section 14 up to section 19A discussion. So I summarized the sections, provisions of these sections. Section 20, section 21, section 22. Very simple. It tells us about mistakes. Mistakes can be of two types: mistake of law, mistake of facts. Mistake of law can be of two types: mistake of Indian law, mistake of foreign law. Mistake of Indian law cannot be a ground for avoiding the contract. Just because you think you have mistaken the provisions of the law, you cannot avoid the provisions of the contract. However, where you have mistaken the provisions of foreign law, you can still avoid the contract. Contract can be avoided. Where it comes to mistake as to facts, there can be two things: bilateral mistake, unilateral mistake. Under unilateral mistake, one party is at fault, whereas the other party is not at fault. Contract cannot be avoided. On the other hand, where both the parties have mistaken the fact, there is no consent at all. So the agreement is void ab initio. In that case, the agreement is void ab initio. So these are the things to be kept in mind with respect to 20, 21 and 22. So important part. Simple parts though. There cannot be, till now they have not asked any detailed question here. Sometimes they'll ask 1 or 2 marks area. Short questions asking you to give the reasons. At that time, probably these provisions might form a part of importance. So with this, we conclude the provisions under section 14, that is free consent. Free consent concept gets over here. Free consent. Moving on further, section 23. So section 19, section 19A already discussed. Section 23, legality of the object. And lawful consideration. Legality of the object and lawful consideration. Here, what are the things to be remembered? Of course, section 23 definition. There are 6 different activities which are considered as unlawful, or where there is an agreement based on those 6 objects, we will consider the agreement as unenforceable or agreement is unlawful. First one is where it is forbidden by law, where you are entering into an agreement for doing such an act which is forbidden by law. Which law forbids? Law says you cannot do such type of agreements. Such type of agreements, when you enter into an agreement, I'll consider it as unlawful object. Agreement with unlawful object. Then, which are of such nature that if permitted would defeat the purpose of the law. So, where agreement is made stating that suit can be filed even after limitation period. Parties agree that suit can be filed even after limitation period. If you allow that particular agreement, what happens is it will defeat the purpose of the law. It will defeat the purpose of that particular act. That is limitation act. That is why such an agreement will not be valid agreement. Will not consider it as valid agreement. If it is fraudulent, or if it involves injury to any person or property, or if court regards it as immoral, or it is opposed to public policy, all these things are to be kept in mind. Important. Now, with respect to public policy, we have certain important things. When it comes to public policy, see, under public policy, there are so many examples for us. Where exactly can we expect the questions? What are the areas where we can expect certain questions? Important. First one, we can expect questions from stifling prosecution. Stifling prosecution. Stifling prosecution is nothing but you are coming in the way of suit running its normal course. If any case is filed in the court, you are coming in the way of it. You are not allowing the court to take its action in the thorough way. That is what is stifling of prosecution. Can be a possible question here. Important area, stifling of prosecution. Maintenance champerity. That is also important. Maintenance champerity, important. Maintenance is nothing but agreement to maintain a suit against other party. Good evening, good evening. Yes. Maintenance is agreement to maintain a suit between a party who is not at all interested. It is just with the intention of creating the trouble to other person. That is maintenance. Third one, champerity, where the party is interested in the outcome of that particular case. Hand over the portion of the proceeds of the action, whatever comes as a result of that particular litigation. If you have a claim on that particular part, that is called as champerity, where you are interested on that. Fourth possible area where we can expect a question is trafficking of public officers. Normally, they'll ask a question like this. A lower officer what he does is, lower officer asks his higher officer to take a VRS, voluntary retirement, and offers payment of 10 lakh rupees so that he can come to that particular position. So whether this is valid, they'll ask a question like this, whether this is a valid part. Since it is against to section 23, provisions are against to section 23 of the Contract Act, I will not say that this is a valid contract. It is void. So you cannot enter because it results in trafficking of public offices. So this can be a possible question here. Possible question. So these are the possible areas where we can expect questions under section 23. Practical questions if I am saying. Theoretical questions. Arey yaar, who is that? So much of emojis someone is sending, so much of hearts. Probably has fallen in law, I guess. So much. Yeah. So falling in law is what we are doing here. Correct? Yes, sir. So section 23. Section 23, these are the important areas. You must remember them. Please make sure that you remember the wordings of these areas, right? So that is section 23 for us. These are the important areas. So that ends one more part there. Yes, sir. So there's one person saying here, very scared, sir, this attempt because of do or die situation. Sir, you focus on only do, sir. There is no question of dying here. Once you are into CA, there is only focusing on doing. There is no question of dying. So only thing at this stage you can do is to put maximum efforts possible. See, whatever the areas I'm saying is very, very important. You stay focused on those areas. You read them. You thoroughly understand them. And try to see questions in those areas and try to find an answer for them. Clearing law paper becomes much easier when you focus on these sections. These are very, very important sections, I say. Because when you see the voluminous topics that you have, cutting down into shorter areas, cutting down into smaller topics, and then learning them systematically is the key for clearing your examination, especially when it comes to professional courses like chartered accountancy. So what you are supposed to do is, you need not see the entire subject as a huge part. You just have to focus on what is important area, what are the important provisions, and try solving the questions. Definitely you can clear here. Yes, this entire marathon session is for that reason only, so that we can assure you that you are near to success and you will definitely achieve, provided you pay right attention and you give right focus to the areas. Now, moving on further, we have certain agreements which are expressly declared as void. Agreements expressly declared as void. Various provisions are there, sir, which are expressly declared as void under the provisions of Contract Act. But what I will pick up as important areas, or what I'll pick up as important is section 27. Section 27 is very, very important. Agreement in restraint of trade. Agreement in restraint of trade. Agreement in restraint of trade means you are restraining someone from doing any lawful trade, business, or occupation. You are stopping a person from doing any lawful trade, business, or occupation. That is what is called as agreement in restraint of trade. Now, there are certain exceptions. Such an agreement is void agreement. Whenever a person is stopped from doing lawful business, trade, or occupation. Now, what can be the possible question, sir? Sir, sometimes the question will be like this. Say you don't want a particular lawyer to take up the case against you. A case might be filed against you. You have a fear that someone is going to file a case against you in a particular matter, and you don't want a particular lawyer to take up that case. So you enter into an agreement with him, promising him to pay a consideration if he does not take up a particular case. Now, after you pay the money, if he takes up the case, or where you have promised and he does not take up the case, and later on you deny to pay him the consideration, in both the cases, law will not recognize this type of agreement at all, because as per the provisions of the Contract Act, it is clearly written under section 27 that such an agreement is void ab initio. You cannot restrain someone from doing any lawful business, trade, or occupation. That is why this is to be considered as void agreement. This will be considered as void agreement. However, we have certain exceptions for this. Certain exceptions. Which are the exceptions possible, sir? Sale of goodwill. The person who is selling the goodwill, he can be restrained from taking up competing business for certain period of time. Of course, you should remember there is a word called as reasonable. He can be restrained from doing similar business within reasonable time, or within reasonable local limits, or within reasonable local limits. So this is an exception to section 27. Second exceptions that we can see. Second exceptions we can see is in case of partnership. While people enter into an agreement for partnership, you can state that the partner or person who is becoming the partner in the firm cannot take up any business while he is a partner in the partnership firm. During his tenure as a partner, he cannot take up any other business. To be very precise, section 11. Section 11 of Partnership Act. Section 11. Third one, in case of retirement of partner. Retirement of partner. Where a partner is retiring from the firm. Where a partner decides to retire from the firm, you can restrain him from taking competing business within reasonable time or within reasonable local limits. Valid one. Or fourth one, as many people are saying here, service agreements. In case of service agreements, in case of service agreements also, the person whosoever is becoming an employee, till the period of agreement or till the period of employment, he can be restrained from doing any competing business. Normally they'll say chartered accountant's office, one assistant comes and joins. Now CA has, or doctor's case they'll say. In all these cases, it will amount to service agreement. So under service agreement, there can be agreement in restraint of trade. It is valid. So no problem with that. These are the exceptions to section 27. Points to remember, very important. One of the important section I say, section 27. And one more section that can take importance is section 30. They may ask you a straightforward theory question under section 30, where we may have to write the essentials of wager, or maybe they will have to write about transactions which look similar to wager, or transactions though look similar but where they are not a wager in nature. So this can be a straightforward question. There is no technical part here to understand. That is why I'm not discussing it in detail. But your theoretical part, whatever is there, it becomes an important part here. So these are the areas to be covered under unit number 3 of the Contract Act. Unit 3 of the Contract Act. Very important. Yes, my dears. I hope you are getting up the things. You are understanding the things what we are discussing here. The detailed part what we are discussing. Even though this is a marathon session, whatever topics I am picking up, I want to deal it in detailed manner so that possibilities of questions, you should get a clarity on possibility of questions. What are the things we are going to write in the examination? Because now it is high time. You put your heart out, you put your best efforts possible, definitely the success will be yours. So all in all, what we are trying to do is we are just adding on to your preparations. It is just an addition that is happening to your preparations. That's it. Nothing else. Yes. So I hope those people who are here are finding it very effective and all areas that are essential for you are getting covered. Yes or no? Yes. One more thing I wanted to say. If there are any students other than Trisha classes, those students who are out of Trisha classes, those students who are not a part of any groups of Trisha classes, for them, I'll just share a number. You can mark this number or you can take this number for notes. These notes will be shared to you. These notes will be shared with you. So whatever notes I am writing here, keynotes, whatever is there, that keynotes you can take into consideration. You can take a copy of that. That is soft copy, like PDF or something will be sent to you. So I'm sharing the number here. You can take it into consideration. And any students other than Trisha students, for Trisha students, definitely it will be circulated in your groups. For other students other than Trisha students, make sure that you just ping to this number or you just call to this number or WhatsApp to this number. They'll send you the notes. So the number is 82968 64927. 64927. So you can take up this particular number. You can ping them. So they will respond to you. It is office number of Trisha. That is especially with the respect to notes part. Yes. So with this, we conclude the discussion on unit number 3 of Contract Act. Predominant discussion up to section 30 gets over. Very important discussions. Right from section 10, we covered up to section 30. So hardly we took around 2.5 hours probably for this discussion, effective discussion. It is because I had to put up different provisions, different questions and various types of discussions here. If it is like you yourself preparing for this area, probably it doesn't take so much of time. Even if you sit at a place and try to recall all these provisions systematically, what I feel is max to max, including all the examples, to recall all the examples and all the possible questions. Up to unit, up to section 30, it hardly takes around 45 minutes to 1 hour. I'm saying detailed revision if you're doing. Briefing out, like recalling the sections, it will hardly take 10 minutes to recall all the sections, at least the headings of the sections. Once headings of the sections become very clear to you, probably the contents should not be very difficult. You can go on interrelating to each and everything. So recalling is the only technique you can do for law. The moment you start recalling, sitting at a place and recalling, closing your eyes, no help of any book, keeping on recalling the things. Whenever you find time, sit and recall. It makes your preparation for law more and more effective. So that is why my request will be that you put maximum effort in recalling the provisions of the law again and again. More and more you recall, more and more you'll become experts with this particular area. So moving on further, what I'm going to discuss next is unit number 4 of Contract Act. Very important area again with respect to certain aspects. Unit 4 of Contract Act, which deals about performance of contract. You entered into contract, sir. Based on the previous provisions, you entered into contract. So what you are now doing is you are now performing it. Or you are understanding the rules regarding performance of contract. What are the rules regarding performance of the contract? Of course, it starts with section 37. 37 is just about the obligations of the parties. What comes next is 38. 38. What will happen when one party is denying to accept the performance? 39 is an important section. Though I have not covered here, I'll cover it in the later stage. 39. An important area to cover. Next comes 40. In 40, what is important, sir? 40 answers a very important question. Who has to perform the contract? Who has to perform the contract? Why 40 is important? They may ask some questions based on 40 where personal consideration is involved. If question is on contract to paint a portrait, if question is on drawing something, if question is on a chartered accountant, if question is on any person where personal skill is involved, hairstylist, personal consideration. That means that person has a skill and you have a confidential relationship with the person and you rely upon the skill of such person only, not on anyone else. Where such type of contracts are entered, we will consider it as contracts based on personal consideration. Contracts based on personal consideration. So there what happens is only promisor has to perform. Promisor himself. I'll put the keywords here. If the contract is based on personal consideration, it must be performed by promisor himself. Promisor himself. Nobody else can perform this. Where there is no question of personal consideration, then in case of death, so in this case, if promisor dies, contract void. If promisor dies or promisor is not able to perform, like he meets with an accident, his hands get cut off. In textbook, we can find such type of questions. So their contract becomes void contract. If it is not personal consideration, then in case of death, legal representatives have to perform. Legal representatives have to perform. Where promisor dies. However, where contract is not based on personal consideration, And if it is permitted in the contract, terms of the contract, then it may be performed either, it may be performed by either the agent of the person promising, that is promiser's agent, or legal representative may appoint an agent. That is also possible. They may appoint an agent, and through agent they can get it performed. That is also possible. Section 40, important. Who has to perform? So this is the possible question also, where personal consideration is involved. You should recall these provisions to answer the question. Very important thing. Right. Section 40. Moving on further, we have joint promises. Under joint promises, what are the things you have to remember? Full one cluster I have given there, 42, 43, 44 and 45. 42, 43, 44, one set. 45, one set. 45, one section. 42 speaks about devolution of joint liability. Devolution of joint liability. Devolve. Devolve means how does it pass on? Lower side. Evolve means it comes up, no? Devolve means it goes down. So, how devolution happens? How devolution happens? That is what we need to see. How it devolves. Let us see how it devolves. Can you see the screen clearly? The screen is clearly visible. Please give me a confirmation. Screen visibility, is it clear? Hello, people. I am not getting any response from your end. Please make sure you're responding. Yes, yes, visible, right? Okay, fine. Yes. Okay. Devolution of joint liability. Let's discuss devolution of joint liability. Devolves. How does it devolve? During joint life. All promisers jointly. During joint life, all joint promisers are jointly liable. Correct? All joint promisers are jointly liable during their joint life. In case of death of one of the joint promiser, death of a joint promiser, one of the joint promiser, if he dies, legal representative of deceased promiser legal representative of deceased promiser plus it is not visible clearly. Few people are saying no. Visible, no? Okay, fine. Just give me a second. Okay. Now I think so it is visible. Not very sure. Okay. My dear students, please give me a confirmation. I'm not able to make out. Because for me it is visible. But I have a doubt whether it is visible or not. Because when I'm checking in my cell phone here, it is not clearly visible. So you confirm if you can see it clearly. Whatever I am writing on the screen, whether it is clearly visible. Okay. Based on the responses, we can say it is clearly visible. Okay. In case of death of a joint promisor, then who are liable in case of death? It is not clear. Okay. It is not clear. Okay. Give me 1 second. Let us make it clear. Give me 1 second. Sir. Sir. Mute, mute ಮಾಡಿದ್ದೀರಾ? Share ಮಾಡ್ತಾ. Okay. Think so a little bit it is rectified. We'll see. We'll continue. Anyhow, we are recalling the provisions. We'll improvise. We'll recall it. We'll continue. Yes. So we were discussing 42. So in 42, what we are doing? 42, devolution of joint liability during the joint life. We said all promisors will be jointly liable. In case of death of a joint promisor, his legal representative of that is legal representative of deceased partner, the deceased promisor, along with surviving joint promisors. In case of death of all joint promisors. In case of death of all legal representatives of all joint promisors are jointly liable. All these are jointly liable. Correct? All these are jointly liable. Yes or no? The next thing, next area to be addressed here is section 43. Section 43, what does it say? Again, an important area to observe. Section 43. Can one of the joint promisors be compelled to perform whole of the obligation? Can you compel one of the joint promisor to perform whole of the obligation? Can one of the joint promisors be compelled to perform whole of the obligation? Answer is yes, he can be compelled. Now he has the right. Whenever he is compelled to perform whole of the obligation, he can compel other joint promisors to contribute equally. He can compel other joint promisors to contribute equally. And when he is compelling the other joint promisors to contribute equally, if any of the joint promisors fail, then the loss shall be borne by other joint promisors equally. The loss shall be borne by other joint promisors equally. These are the things to be kept in mind with respect to section 43, compelling one of the joint promisor. That is why I say liability of the joint promisor is joint and several. So in this case, it is several. So that is the case. After that, what happens? Section 44 comes. In section 44, what do we understand? Section 44 speaks about effect of release of one of the joint promisors. What if one of the joint promisor is released from the obligation? What will be the consequence? Now, if one of the joint promisor is released, it will not release other joint promisors. Other joint promisors continue to be liable for the whole obligation. Remember, don't do proportionate and all. Don't divide it. Now, if the amount payable or joint promise is to pay 9 lakh rupees, one of the joint promisor is released. Now, don't say only 6 lakh is liable. Other joint promisors are liable only for 6 lakhs in the Heldikilla. You cannot say that. Sorry. You cannot say that. You should clearly understand that the provisions state that other joint promisors are liable for whole of the obligation. Obligation is complete. Only thing is that joint promisor who is released cannot be held liable by the promisee. Promisee cannot hold him liable. But it will not make him free from being liable to other joint promisors. That means he continues to be liable to other joint promisors. So section 44 has two important observations. When you release one of the joint promisor, only he is released, other joint promisors continue to be liable. Further, when one of the joint promisor is released, he will not be released from the liability to other joint promisors. He continues to be liable to other joint promisors. This is 42, 43, 44. One of the important cluster where there can be a question. Then comes 45, devolution of joint rights. Similar to devolution of joint liability. Only one section is there with respect to joint rights, where promisees are multiples. Multiple promisees are there. In that case, what happens? Where multiple promisees are there, during their lifetime, they jointly have the right for performance. They can seek the performance jointly during their lifetime. In case of death of one of the joint promisee, when one of the joint promisee dies, his legal representative along with other joint promisees shall be jointly liable. liable, they have the right. They have the right to claim performance. In case of death of all the joint promises, what will happen? Legal representatives of all joint promises jointly can demand for performance. These are the contents of section 45. These are the contents of section 45. So thereby joint promise part ends. This is one cluster. Wherever a question comes about joint promise, you have to recall immediately the answer should be related to 44, 42, 43, 44 or 45. Any of these provisions. So even the question will have joint promise content only so that you can make out easily. Simple things here. But you have to remember that the provisions, these three provisions are related to joint promises, and 45 relates to joint promisee. 45 relates to joint promisee. Is it clear, sir? Shall I proceed? After going for 45, the next topic we need to cover. Next topic we need to cover is 53. In between, there are few miscellaneous sections which are not very important for a point of discussion here, which can be asked one or here and there, they can be expected. But what I say is, when I say super 100, I'll not cover those things in the super 100 part, because these requires lot of weightage. Whatever I'm covering as super 100 requires more weightage. That is why I am focusing on these areas. So going by section 53. Section 53 is a part of reciprocal promises. Now 53 makes an important observation. What does 53 say? When one party prevents the other party from performing his obligation, one party has a responsibility to allow the other party to perform, but where one party prevents the other party from performing his part of the obligation, the party so being prevented, the party whose performance is prevented, can put an end to the contract. That means the contract is voidable at the option of party so prevented from performing. Whichever party whose performance is prevented, he has the right to put an end to the contract. Further, he can also claim for damages, compensation. He can claim for damages, that is compensation. That is what is section 53. Liability of the party preventing performance. Party prevented can avoid the contract. Party prevented can avoid the contract and claim compensation. Claim compensation. Again, important area, 53, important. Make sure that you understand this. Liability of the party preventing. So important part. Next, even 54 is important. 54, where contract is dependent. One promise is dependent on performance of another promise. Then what happens? If party who has to perform first defaults, if party who has to perform first defaults, other party has an option to avoid the contract. And he can also claim compensation. He can also claim compensation. Again, another important section to recall. 54, important. 53, 54, both are important. One, preventing the other party. The other one, performance of party who has performed first, who has to perform first. He defaults in performing the obligation. Other party cannot perform, where it is dependent. One party says, I'll supply the raw materials You manufacture the goods and give it to me. If the party who has to supply the raw material fails to supply, other party cannot be compelled to perform his part of the obligation. And further, the party can also claim compensation. The party can also claim compensation. This is the part. Next important cluster I need to see. Next important cluster we need to see is, okay, the visibility is not clear. I am at the fag end of this particular unit. I'll just cover this 3 sections. Probably we can recall, even though it is not visible, we can recall it. Rest of the units, probably we can cover it in the next session, not an issue. Okay. So we'll recall these 3 sections now, 59, 60, 61, quickly. It is one more cluster which speaks about appropriation of payment. So even though it is not clearly visible, please pay attention, my dears. Let us keep the spirit high. So technical errors sometimes happens. We cannot help it. Sometimes it goes beyond our control, correct? So this technical difficulty, whatever is there, will be rectified. But for now, please pay attention on our discussion. Appropriation of payment. Now you have to understand under which scenario these provisions are to be applied. Very, very important. See, normally in a question, they will form a case where there will be a creditor, there will be a debtor. And this debtor owes multiple debts to creditor. Not one debt, multiple debts are there. Many debts are there. And he has to pay the money. Now, whatever money he has paid, it's not sufficient to cover entire debt. It's not sufficient to cover all the debts. In that case, how to apply the money for settling the debts? That question will be addressed using these 3 rules. So when money paid by debtor is not sufficient to settle all the debts, section 59 says, debtor may indicate the debt against which the money can be appropriated, where he indicates it must be appropriated against such debt only. So where debtor indicates the debt against which it must be appropriated, where debtor indicates the debt, that means debtor is giving the indication. Now you have to observe one more thing here. Indication of debt, you have to observe importantly. Even in ICI material, there is an important question. Indication of debt against which the money is to be appropriated need not be express indication. He need not expressly state. Suppose if there is a particular amount of the debt, and if he gives a check equivalent to that particular amount, it means that it is an indication. You should consider it as indication. Remember this while answering the question. When he gives a check or when he gives an amount which is equivalent to some loan amount, it should be considered as implied indication, my dears. It should be considered as implied indication. You should consider it as implied indication. Hello class, are you all getting it? Yes. Are you all understanding? Implied indication. You should consider it as implied indication. So, where debtor indicates the debt against which the amount is to be appropriated, it must be appropriated against such debt only. It must be appropriated against such debt only. Yes. So, where there is a clear indication, it must be appropriated against such debt. Second one, this is section 59. Section 60, what does it say? Where there is no indication, creditor may appropriate against any date, creditor may appropriate it against any debt. It need not be any specific debt. It can be appropriated against any debt. So very, very clear. Make sure that you are clear with this provision. It may be appropriated against any debt. Remember one more thing here. This can be even time barred debt, including time barred. That means you can appropriate it against time barred debt also. You can appropriate it against time barred debt also. However, you cannot appropriate it against disputed debt, not against disputed debt. Not against disputed debt. Very nice. Disputed debt means a debt against which a litigation is going on in the court. A debt against which a litigation is going on in the court is called as disputed debt. You cannot appropriate it against disputed debt. Make sure you are very clear here. Yes. Moving on further. 61. Where both the parties are not appropriating, either the creditor nor the debtor are appropriating. That means money received is there in one account, money to be received is in one account. It is shown separately. None of them have appropriated. Debtor has not given the instruction, creditor has not appropriated. Then section 61 will come, which clearly says that it must be appropriated against such debt. Which falls due first. So based on due date, you have to appropriate. Whatever falls due first, it must be appropriated against such debt. Whatever falls due first, it must be appropriated against such debt. This is what is the point you have to observe under section 61. Appropriation, where neither party appropriates. Now, more than one debt, if they fall due on same date, proportionate appropriation has to happen. Proportionate appropriation. Proportionate appropriation. That means in the proportion of due, you have to appropriate it. So these are the things to be kept in mind when it comes to 59, 60 and 61. Then there are two categories of sections which tells us contract need not be performed, 62 and 63. There the wordings are very important. 62 tells us about three types of scenarios. Which are they? Can you recall? 62. What are the wordings said in section 62? Contracts that need not be performed. It tells us about novation, rescission, and alteration. Novation, rescission, and alteration. Novation means substituting an old agreement or old contract with a new one. Novation, nova means new. Very nice. Novation means substituting an old agreement with a new one. No new old contract with a new contract. Now the speciality of novation is that parties need not be same. Parties can be different parties also. The parties to the contract need not be same parties. Parties can be different parties. So novation, that is novation. Original contract need not be performed. The new contract has to be performed. Rescission means both the parties mutually agreeing not to perform. That is rescission. And alteration means altering the terms of the contract. Altering the terms of the contract is called as alteration. But possibility is that they may ask you to write the difference between alteration and novation. Alteration and novation, differentiation can be asked as a question. Important area. Difference between novation and alteration is important. And 63 tells us about two more situations. That is, one is waiver and one is remission. Waiver means total giving up of rights. Whatever the rights you had in the contract, this is totally from the promisee's angle. 62 mutual agreement. 63 from promisee side. When promisee gives up his right to recover or to ask for the performance, it is called as waiver. And then comes remission. Remission means settling for something less than what originally is promised. Originally, whatever the amount was promised, or originally what was the actual promise, you are settling for something less than what is actually promised. That is called as remission. You are remitting the performance. That is called as remission. So this is one more area to be kept in mind. 62 and 63. With this, we literally conclude the Unit 4 of Contract Act. Unit 3, Unit 4, both are done. Unit 3 and Unit 4. Two important units where we can expect certain important questions. So, in our target 100 sections, what are the things that we have covered? We'll quickly compile it once. We'll quickly compile the things that we have covered for the day. So, first and foremost, Section 2 Clause H was covered. This was the first topic. Second one was offer. Third one is acceptance. Agreement, I'll not take it as a separate topic because no specific point to discuss here. Topic number 4 was Section 10. Topic number 5, general offer versus specific offer. Essentials of valid offer, I'll keep it in offer only, offer part. It is a part of the definition only. Essentials of valid acceptance also, I'll keep there only. Topic number 6 is Section 4. Topic number 7, Section 5. Standard forms of contract again comes in communication only. I'll not make it separate part. Again, consideration and legal rules governing consideration. Topic 6. Topic 7, Section 25. Topic 8, Doctrine of privity of contract. Topic 9 that we covered today is Section 11, Capacity of the parties and legal status of agreement with minor. Topic 9. Topic 10 is Section 14 and its effect. Totally we have discussed together as topic 10. Topic 11, Section 23. Topic 12 was Section 27, Agreement and Restraint. So with this, we concluded unit number 3 also. Unit number 3. Then came unit number 4, where we discussed 13th topic. Then came joint promise as 14th topic. Section 53 as 15th topic. Section 54 as 16th topic. This one more cluster, 59, 60, 61, appropriation of payment as 17th topic. 62, 63 as 18th topic. So these were the 18 different topics. Topic wise, if I have to speak, 18 different topics that we discussed for today. So that means the voluminous cluster of Contract Act is reduced into smaller topics. So all in all, we can say around 20 to 25 topics will be there for covering in your examination, out of which you can expect the question. 20 to 25 topics, I'll say. So whatever the topic division I do, if you focus on that particular area, probably recalling the things and remembering things will be much easier. Yes. So probably for today, since we have covered two major areas, that is your 42 as a unit 3 and unit 4, and also in the morning session, we have covered substantial part. I think so for today, we can end the session here. Tomorrow, we can cover the other two units that are remaining in Contract Act. Of course, the breach of contract and its remedies, and the quasi contract and contingent contract, simple parts. Then we of course have the Sale of Goods Act, which we can cover detailedly in tomorrow's session. So please do let me know how are you feeling after attending 3 sessions for today with respect to marathon. How exactly are you feeling? Please be honest here. Please make sure that you share the particular insights so that tomorrow something more can be given in the sessions, something more effective discussions can happen. I hope you are all understanding the topics that are going on. You are in a position to recall the things as we discuss. Yes. Yes, my dears. Yes, super. Yes, sir. So then, shall we call it a day? Shall we end the day for today? Shall we meet tomorrow? Morning 6:30. Shall we? Yes, sir. So please keep your spirits high. Keep revising. Please recalling. Keep recalling. Till then, we'll meet back tomorrow morning again, and we'll discuss furthermore topics. Tomorrow's coverage will be probably 2 units of Contract Act and one more unit, probably 1 or 2 units of Sale of Goods Act. We'll see. So for today, we'll end the session here. Thank you. Take care. Have a good day. Bye bye.